In today's video, I'm going to explain how employment lawyers prove discrimination. Hello, welcome to my channel. My name is Brandon Ortiz and I am an employment lawyer in Burbank, California. Today, I'm going to explain how employment lawyers prove discrimination in the workplace. But before we dive into the video, I just want to give you a quick reminder that this video is not legal advice. If you need to know your specific rights, or if you have questions about your specific matter, you should directly contact an employment lawyer. If you're in California, you can reach me at 888-37-ORTIZ, O-R-T-I-Z. That is 888-376-7849. In employment law, I would submit that the single most difficult type of case is a discrimination case. Retaliation cases, sexual harassment cases, race harassment cases, those are much easier to prove. But discrimination cases are very hard because very rarely will a person come out and admit that they're doing it for discriminatory reasons. So most often in these cases, we have to prove the discrimination through circumstantial evidence. So I'm going to walk you through some of the most common ways that we do that. But I will give the caveat at the very beginning that it usually takes a combination of the types of evidence that I'm about to talk about. So any one of these things that I'm about to go over standing alone may not, or probably not, is sufficient to prove discrimination. You really need these things in combination with each other. But without further ado, here we go. Okay, so way number 5 is when an employee's performance reviews dramatically change after a change in supervisors. And the longer the employee had been employed prior to the supervisor change, and the better the reviews prior to the supervisor change, the stronger the inference of discrimination. One thing that is very common is that a non-prejudicial, non-biased person will hire somebody of a certain minority group or of the female gender or LGBTQ, and this non-discriminatory, non-prejudicial person gives them great reviews. But when a new supervisor comes in, all of a sudden this employee is the worst employee in the world. And if the employer is not able to articulate a reason why that the review suddenly changed, and this employee is now all of a sudden the worst employee in the world, that does give rise to an inference of discrimination. It's not the strongest inference, and in the vast majority of cases, this fact standing alone is not going to be enough to move the ball past the past the end zone. But in combination with the other evidence I'm about to talk about, it does help support proof of discrimination. The fourth method is a little bit more powerful, and that is evidence that the reasons that the employer is offering for the termination are false, contradictory, shifting, or implausible, or unworthy of credence. Those are all telltale signs of pretext. Pretext means that the reason that the employer is giving is not the real reason. So they say that they are terminating an employee for performance, or they say that they are terminating an employee because they were tardy, but in actuality, the real reason is because of the employee's protected characteristic, race, gender, disability, etc., etc. The third method really only applies to pregnancy and disability cases. And it's very closely related to number 5, and that's timing, okay? An employee is getting great reviews, becomes pregnant, announces that they need pregnancy leave, and all of a sudden they get bad reviews, and all of a sudden they're a bad employee. Or an employee gets good performance reviews, gets in a car accident and has a disability, or gets breast cancer, etc., and all of a sudden that employee is a bad employee. Both of those create an inference that the pregnancy or the disability, that is what's driving the sudden change in the employer's perceptions of the employee. The second method of proving discrimination is disparate treatment. Evidence that you were treated differently than people of different protected statuses or protected categories. So if you're African American, evidence that the employer treated you differently than other Caucasians, or evidence that the employer treated Hispanics differently than Caucasians, or treated men differently than women, and vice versa. The example I like to give is, let's assume a hypothetical where two people show up late to work one day, and they both had the exact same track record on attendance, both good performers, same supervisor making the decision, and they're the same in all respects except one person is white, the other person is Hispanic, and the company decides to fire the Hispanic for showing up late to work, but they don't fire the Caucasian for the same thing. In that case, you could infer that the real reason isn't because they're late, it's because of their race. Another way of proving disparate treatment is through Me Too evidence, and that is evidence of discrimination towards others in your protected category. So if it's a pregnancy discrimination case, one way you could prove pregnancy discrimination is if you can show that the company has fired other women after they became pregnant, because the inference is that that's just what the company's modus operandi is. That's their motive, is they fire women when they become pregnant. Now there are limits to this evidence, and it has to be close to your workplace, and it has to involve either the same supervisor or the same group of supervisors. So if you're in California and you can present evidence that somebody in Florida was discriminated against by a totally different manager who has nothing to do with your workplace, that evidence judge is not going to let that evidence in. So it really needs to be preferably the same supervisor, but at least the same group of supervisors, like your boss's boss or your boss's boss's boss. But the further away you get removed from the person who actually made the decision in your case, the less likely that the Me Too evidence is going to come in to evidence. What I mean by that is that the defendant, the company, could object to the evidence at trial, the court sustains the objection, and the jury never gets to hear the evidence. That's what I mean by that. The number one method and the most powerful method of proof in discrimination cases is what we call direct evidence. Now, the strongest form of direct evidence would be just a straightforward admission. I'm firing you because you became pregnant. I'm firing you because you're a woman. I'm firing you because of your race. As you can imagine, extremely, extremely rare for people to come out and say that. Another form of direct evidence is when the person makes discriminatory comments. So let's say it's a gender discrimination case, and you have evidence that this guy was just, the person who fired you was a sexist pig and would make degrading comments about women, make sexist jokes about women. That's usually the strongest evidence, short of a blanket admission. In the past, judges were much quicker to block that evidence from coming in under what was called the stray remarks doctrine. And essentially under the stray remarks doctrine, if somebody made a racist comment about another person, and that comment wasn't directly linked to the termination, judges would frequently prohibit that evidence from coming in, say it's unduly prejudicial. And, as you can imagine, that really makes it difficult for employees to prove discrimination. Here in California, thankfully, the California Supreme Court has rejected the stray remarks doctrine. And the California legislature has actually codified that into law and said that, discriminatory comments, even if they are not directly related to the termination, they're still probative and relevant evidence to a discrimination case. Thank you for watching today's video. Please don't forget to click subscribe, like the video, give it a thumbs up if you liked it. If you have any comments, if you have any suggestions for videos to make in the future, please leave that in the comments section. If you need help with your own employment need and you're in California, you can call me at 888-376-7849. 888-376-7849. I've also left my internet address down below. Thank you for watching and have a good one.